Thank you. I'm the opening batsman, and I think this is a very important question. We all should be knowing this, that we do not have to enter all these in a MTP register. So you don't have to enter a missed abortion, an incomplete abortion, an inevitable abortion, an ectopic, and HMOL. So that should be very clear.
So basically this is mentioned in this guidelines of Government of India, that these are the things underlined lower down, that inevitable abortion, incomplete abortion and all these things are not to be included in MTP, and we should not register, put it in the entry should not be put in MTP register. Now what is the legal status of fetal reduction? Should we fill the forms of MTP for fetal reduction or not?
Okay, it is still not very clear, even after the amendments that we had right now of the Act in 2021, whether this is fetal reduction should be considered as an MTP. So as of now, fetal reduction is not MTP, so you do not have to enter it in the MTP register.
As such, it is prudent because we are not terminating pregnancy as such. We are just reducing one embryo or fetus.
Actually, what we have come to understand is that the definition of MTP itself is not very clear. So, as of now, the guideline that is there is that you do not enter this in the MTP register.
Yes, very true. Now, between 16 to 18 years, one patient has come whose consent is to be taken to do MTP in such cases.
I think it should be very clear that the consent has to be of the guardian. So guardian means anyone under whose care that girl is. So less than 18 years is a minor, and the consent has to be given by the guardian.
So let us clear one thing, that guardian means it is guardian, not legal guardian. So here word used is guardian. So anybody who guards, even boyfriend who is above 18 years can sign for the MTP. So patient is of 15 years, pregnant with 12 weeks. Guardians giving consent for MTP while patient is refusing to undergo MTP. What to do in such situation?
I think this scenario is something which we are going to be seeing a lot more in the future. And this is very important, that while the patient is a minor, but she is definitely more than 12 years. So you cannot go against her consent. So in such a situation, it's important for the guardians to sit down with the patient and discuss with her the pros and cons, to understand that keeping a pregnancy would involve so many things, financially, emotionally, and also I mean, who's going to support the baby. But ultimately, you see, it is the patient herself who has to give the consent. And if by discussion it is very clear that the guardians feel that she should go for a medical termination, then they would have to approach the court, because you cannot go against the wishes of the patient now that it is very clear that she is more than 12 years of age.
So the basic understanding should be that in criminal law, the age of understanding is considered as 12 years. And in Indian Contract Act, age to contract is 18 years. So if a case is filed against you in criminal law, then the 12-year age will be considered as the age of understanding. So anybody above the age of 12 years, if refuses for the treatment, you cannot proceed for the same. So in such situation, wherever there is discrepancy of the decision in between guardian and patient, it is your duty, or it is guardian's duty, to go to court to take the decision of court that it is in the benefit of the minor to go for MTP.
Dr. Geetendra, can I ask one question?
Yes, madam.
The age that we are all talking about, which is now given, is 18 years. I remember that you were mentioning that there is some, there is going to be an amendment, or there is going to be a change. Is that so?
See, basically, under POXO Act, what we are considering is, under POXO Act, the age, if below 18 years, if patient has undergone any sexual assault, then it becomes our duty as per section 19 to inform police. And that is 18 years we should remember. See, there is one judgment recently came from Supreme Court, 3-judge bench, including Justice Chandrachud was one of the member of the team. And that judgment clearly mentions that if patient is even below 18 years and above 16 years, and then if patient gives you in writing and the guardian gives you in writing that we do not want to divulge the name of the lady or girl, then you may not inform police. So that kind of judgment has come, but till date we do not know what will be the implementation of this judgment, because law is saying something else. So we are supposed to follow law till some clarity will come. Okay. Now patient is of 18 years and 3 months. Patient of 18 years and 3 months having full term pregnancy, married, will you inform police?
So in this case, patient has had sex when she was under 18, that is at 17 years. We should inform the police.
So message is whether patient is married or unmarried. If patient at the time of becoming pregnant or having sexual intercourse is below 18 years, it becomes our duty to inform police. Okay.
One thing more, it is mandatory to inform even if you have the knowledge that this patient, under the Act, POXO Act, it is mandatory to inform the police even if you anticipate that this child is going to have the sexual abuse. Otherwise, there is a fine and jail also up to the term of
Correct.
6 months.
Correct.
Now there is one patient having more than 24 weeks pregnancy and having multiple fetal anomalies including anencephaly.
So-
How will you proceed in such
Yeah.
case?
So such case is to be informed, in which the district head office is taken up the case and they will send it to the national board. A national board is formed. And this,
State board.
the state board, yeah, the state board will be formed. And this state board will decide within certain stipulated time, and as soon as
72
within
hours.
72 hours, and as soon as they decide, they will fill up a D form and they will give it to the to the organization, and then the termination has to be performed within 48 hours.
Okay. So
I think I want to say, it's like medical board is already in place under the direction, so patient directly come to us. We don't send to state board or some, directly comes to us. We form the medical board is already there, name of the persons are there. We call the medical board and then we decide then and there in our hospital. We don't send to state board or this thing.
see, basically,
if it
who are
comes to me, when-
who are the members of state board
We are
or
not
district medical board, whichever is been formed, it is not clear to the public.
Correct.
So-
We don't have a state board,
Yeah, so
so,
that's why it is always advisable to send the patient to CDHO.
Correct.
And CDHO will send that patient to district medical or state medical board. And there are minimum three members in this board. One is pediatrician, one is sonologist.
Gynecologist and a sonologist.
Gynecologist.
Correct.
And even more members can be there. Yeah. Yeah.
100%.
Now, see, we know that in PNDT Act, no uniformity of implementation is there. So there are a few questions. My center is registered as ultrasonography clinic. Now I want to change the registration as genetic clinic, as I have started doing ART practice. What to do?
So it totally depends on the area appropriate authority. Now, in our area, there are certain guidelines. If we provide those documents, our appropriate authorities will change. Otherwise, there is no such provision. I mean, it is to different areas, it has different rules and regulations. But in our area, there is a regulation in which we can change it. Otherwise, in other areas, there is no uniform rule.
So to understand basically Rule 13 in PCPNDT rules, it says that there are provision of intimating the authorities, appropriate authorities, the changes, but there are only three things which are mentioned in that: change of employee, change of equipment and change of place. There is
Right.
no mention of change of category.
Correct.
So as there is no provision of change of category, every
Depends.
appropriate authority is interpreting the act in its own way. Somewhere they are taking the difference of money, means 25,000 plus 10. So they take 10,000 and they give the permission. Sometimes they ask to reapply and take a fresh. So there are discrepancies of interpretation, and that is the problem with PCP and DT Act.
It is always safer to intimate, as you write.
Another important thing is the person who is doing the ultrasonist, they have to confirm the registration of the place where they are going. Otherwise, there is a punishment for it also.
That is right.
Okay, I am skipping a few questions as we have a short of time. Can you demand a copy of Form F from the PCPNDT authorities?
Yes, you can. You can.
Under PCPNDT Act, all the documents are public documents, and you can very well demand Form F of any hospital under that. At how many centers you can register your name in one district as a sonologist?
Centers you can register, not more than
Now
two
the-
centers.
Initially, this directive had come that you can be at only 2 in a district, but now there is a corrigendum, or still it is pending. You can apply, because IRIA had, challenged this. They had put, PIL was put, so it is still.
It has come in the act.
Radiologists Association has gone and put in a stay order for this, and as of now, it's not there, but like it's correctly said that even now there are some people who interpret this by saying only 2 are allowed, only 2 centers are allowed.
See, the purpose of every panel is over once there is discrepancy in the panelists. So, so we are enjoying.
But sir, the final verdict is from you only, na? Being an expert. We are
But
not experts.
all the places radiologist goes, they must be registered centers, and he himself, and then his name or her name should be in the list of empaneled radiologists of
And
that
whenever
particular-
there is
So
a change in-
Madam, from every state, we have received complaint from our doctor friends that, sir, we have applied to the authority, but they are refusing to register my name as a sonologist, as I have already been registered in 2 centers in my one district. So they are refusing. So definitely, as per law, on 4th June 2012, there was an amendment, that was Rule 3, subsection 3, which mandates that one doctor can register in one district at not more than 2 places as a sonologist. That was the provision. But that provision came on 14th June 2012. But a stay was granted on that particular amendment immediately on the very next month. And 5 different cases were filed in 5 different high courts, and all 5 high courts gave stay on that. So we should show this judgment to the appropriate authority so that he can understand this thing, because they may not know the judgments of different high courts. And after these 5 judgments, when the question was raised that in all these states everybody should go in court to get this stay, so the answer was from the Delhi High Court was that as Union of India is the party in this case, there is no need to go to every state to take stay, because it applies to Union of India, and it becomes the duty of the authorized person from Union of India to give the information to all the appropriate authorities all over India. And at that time when this judgment came, Mrs. Anuradha Vemuri was the in charge of MOHFW, and she sent this letter to all the appropriate authorities all over India, saying that there is a stay on this particular section which is amended. In Consumer Protection Act, Madam, are we in now? Very much. So, we all know that. Patient is a consumer. Yeah. So, we all know that after this CPA had come, there is no mention of word doctor in that as a service provider, and we were rejoicing that we are not in now on. But it is implemented by the court in such a way that doctors are still in. And a PIL was filed by MLAG in Maharashtra High Court as well as in Delhi. And in both the cases, they lost the case. And 50,000 fine was rather put on MLAG for countering this kind of acts in the court of law. So we are still in.
The court said that it was not, including all the service providers. It was not exclusively involving all the service. So by the way, they had just put examples, and our example was not there. That doesn't mean that we do not come under purview of CPA. And this was clarified in another, judgment which was given by some judge later on, that we are very much in.
Now for filing a case in CPA, that is in Consumer Protection Fora, is it necessary to have expert opinion?
No, it's not necessary to have an expert witness. Any person can file it. They can write it on paper. You don't even need a stamp paper to do it. You can send it by post. You can use an advocate. You can do it e-filing also nowadays.
Yes.
That is required.
So basically why this question had come, because in 2009, Justice Markanday Kadzu and Justice Lodha gave a judgment of M. D'Souza versus Mohammad Ishfaq. And in that judgment, he mentioned that expert witness should be made mandatory to file a case. But for 1 year, that judgment remained. And for 1 year, no case was filed against any doctor, because no doctor is going to give witness against their colleague. So no case was filed for 1 whole year. And very next year, in the case of Krishna Rao versus Nikhil Multi-Speciality Hospital, this judgment was overruled. And immediately all the pending cases were filed in 2010 and 11 against doctors. Now, day-to-day issues in practice. What to do when patient does not pay and also not ready to leave your hospital? How will you handle this situation?
Financials are not something which, because of which you should deny treatment to the patient. You have to treat the patient. The only thing is, if he is not ready to leave the hospital, you can, take the help of police, or you can refer the patient to a government hospital, but you cannot deny treatment. That is very important.
So, by law says that you cannot stop the treatment
You
for
cannot.
financial reason. And that's why almost all corporate hospitals now taking in advance. And at the time of discharge, they are returning the excess money to the patient.
The patient in the OT before the full amount is paid.
There
So
was
these are the judgments, madam, and one judgment of Ruby Hospital of Calcutta in this regard. And in that judgment, it was mentioned that if you cannot stop the treatment for the financial reason, it is illegal. Not only illegal, it is unethical also. So even in State Medical Council, action can be taken against you.
And there
for
was
that.
an interesting read, sir, I was reading about this question, that they said that you should, assess this particular patient regarding psychiatric assessment, or try to study the socio-economic background of this particular patient, why this patient is behaving particularly in a particular way that he is not leaving the hospital. So that may be, added to this.
Now a few tricky question, madam.
Malingerers will not leave the hospital.
Madam, now a patient in your hospital is suffering from severe pre-eclampsia. It is a case of impending eclampsia. Advice CS, patient refuses. Now patient refuses to take discharge also, and patient refuses to sign refusal consent
This
also.
problem we face on day-to-day basis. We take the relatives into confidence, and we explain all sorts of complications which can happen, and most of the time relatives make that lady understand, and they sign. Whenever I'm working in a government hospital, we'll do like this.
No, but
Or
suppose patient does not understand.
if patient does not give consent, we cannot go ahead, because consent of the patient is must for each and every procedure we are going to do on a particular patient. So that is must. But we should make an effort to convince the patient so that she understands what is best for her. That is way.
But here comes the role of the documentation. You have to document
We have-
the
if the
refusal
patient
and
refuses,
everything.
then we have to
And take a
document.
help of your colleagues
Yeah,
also.
that is
So the
correct.
most
Another
important
colleague
thing is,
And in our
if such a situation
if
comes
it is
and
emergency, if it is required, we take the help of the medical superintendent also, and somehow we convince the patient.
so if
that-
nobody is available, then the next, gynecologist who's there available, both of us write it down and, write down that this is required. The patient is refusing to, and is also not going to be writing down that they refuse to
Yeah, it has to
undergo
be
the cesarean
documented.
section. And as a witness, if we do not get anybody,
then relatives can be
we can
witness
take
also.
a witness of some other patient, attendant, who is there, who may be your patient or the other doctor's
So in
patient.
such
That
situation,
can
there
be
is
taken.
importance of documentation. We should
To
document
protect
it in a
ourselves,
proper
yeah.
manner. Suppose patient is not giving consent and not ready to sign the refusal consent, you should document in presence of one of your colleague. You should explain pros and cons and details of the treatment to the patient in presence of other colleague. Both should write in the case paper in the presence of two independent witness. That will become more authenticated for the court of law. Now, role of police in such situation. Is there any role of police in such situation?
I don't think police, it should be the last resort, but most of the time our colleagues, medical superintendent मिलके सारा sort out कर लेते हैं. Then police क्या
अगर
करेगी?
नहीं मान रहा है तो आप एटलीस्ट इन्फॉर्म कर दो, you will be
Inform
safe.
कर सकते हैं, बस उससे ज्यादा कुछ नहीं.
Now, what is, madam, I will have to go fast because time is less. Now, what is out of court settlement? Is it advisable?
This is the legal agreement between the two parties which are in dispute, And of course, in certain cases, it is advisable to save money and this thing, time also. But as far as we are concerned, medical negligence, it can go against us. So we have to be very careful. We should read the terms before agreeing for such a thing. Otherwise, as far as
Even if
possible, it
you
should
do
be-
out of court settlement, there is no guarantee
But
that
whatever
patient is not
agreement is there,
file a
it
suit
has to be
against.
Dr.
ratified in
Geetendra is
the
going
court,
to give the
and
final
it has
verdict.
to be registered in the court. Then only the case can be closed, otherwise not.
So basically, out of court settlement means without going to court. If you settle by sitting with the patient, that is never advisable. Because whatever amount you will give to the patient, you can never buy the rights of an individual to sue. You cannot say that after taking 10 lakhs rupees, I will never sue you. And even after taking money, they can sue. And there they will say that doctor had given me 10 lakhs rupees because doctor was negligent. So they will use this thing against you. So out of court settlement will never become a legal settlement.
Sir,
So if you do out of court settlement, then you should go to the court and
Arbitrate.
channelize it through the court. Then only it will become a legal
Court will
document.
define an
Yeah.
arbitrator and then you
Yeah.
can negotiate.
And
yeah.
now in new CPA, there is a provision of mediation. So every case when filed, where there is not the case of death of a patient or grievous hurt of a patient. So if simple negligence case is there, you can definitely sit down in the court in the presence of one mediator, and you can with the help of mediator decide the amount and pay through the court, and that will be the better idea. You can also settle in Lok Adalat also. Yes, coming to that, madam, coming to that. So suppose, which are the cases where you will be advised to go for out of court settlement?
Where we are thinking that criminal case can be put against us, then in that case it's better to be, because our case is not that strong.
Yes.
So we have to be more pro towards the out of court.
Yes, yes. So whenever you feel that some criminal litigation can be filed and you may be held liable under criminal law, it is advisable to do out of court settlement and give money whatever patient demands. What is DAR and DAMA or LAMA or DAMA? What is that?
This I like to say that because most of the time in our hospital, when suppose the wound gape is there and the patient doesn't want to stay, she says, "Okay, I'll get the dressing done." Then we do the discharge on request. But as per legally, there is no terms called discharge on request. But we do like that. And second thing is that discharge against medical advice. So many times patients ask they will want to go leave the hospital. They want to. Then in those cases, we have in our case sheet there is a format for left against medical advice. We get it signed by the patient and let the patient go.
So basically in DAR, you entertain the request of the patient. So your legal liability continues. But in DAMA, it is against your medical advice. So your legal liabilities are over once patient is going out.
But you have to hand over all the treatment and.
Yeah, it is prudent to write a slip that although the patient had left the hospital against advice, still the treatment must be given. It's not like Bagadiya was.
Now, when you advise post-mortem in a patient?
Post-mortem will be applied when there's a sudden and unexpected death, when you really do not know what the cause of the particular death is. If there's a death on table also, you would prefer to get a post-mortem done in these cases. And if not done, what are the consequences? Then you get liable for the cause. They are likely to sue you because you really do not know what it has to be done, and in court of law you will not stand strong. So if you have a post-mortem report, then at least you are standing strong with that. And of course, it's when you inform the police, whenever there is such a sudden unexpected death, you inform the police, take the consent, and the police then takes them over for a post-mortem.
Yes. So post-mortem is the duty of police to execute the post-mortem. So our duty is to inform police. As soon as doctor will inform police, police will come, take the statements of different people, and if they feel that there is some foul play or there is need for post-mortem to know the cause of death, they may manage for the post-mortem. Now, this question is, can doctor remain present while post-mortem is being done?
Yes, one can be present at the post-mortem because it's a right, we can be there, but it has a double-edged sword. If you're there, then the patient, the relatives may think, "Ye doctor wahin khada tha, this ne influence kar dega, iska friend hoga." So it is a not very clear situation whether one should be there or not, and you would be the best person to tell us.
So basically there are two contradictory judgments by Supreme Court. Both judgments are from Supreme Court. In one they have said that it is a right of doctor, he can remain present. But in another case they have said that the doctor will influence the process of post-mortem, and that's why he should not remain present. So these are controversial judgment by same court.
What is most safe for us? Should we be there or not be there? We should try to be there. According to you, according to legally, we should be there, we should
Now,
not.
how long to preserve the document? This is most common question, and we should understand.
We preserve the document for 2 years.
Okay.
And if the case is going on, legal proceedings are going on, then the document has to be preserved till the disposal of the case.
Okay, so 2 years. Anybody else?
5 years
PCP
for
and DTL. PCP and DTL.
5 years.
act, it depends on the act. You have to follow the guidelines given in the act.
For PCP, it is 2 years. 2 years.
Indoor, 10 years minimum, or till, if the case is there, till it is pendent, you have to preserve.
So
Even
we-
OPD.
Madam,
OPD.
we were running one diploma course in Delhi, and I think 4 out of 5 were my student in that. Three out of 5. Okay.
All are
So-
those students.
So out of 3, 2 failed today. I am unhappy today.
So, there is one more aspect, our pediatrician friends are sitting here, they say that, regarding
See,
pediatric,
whenever there is a
till they become
specific,
adult, they say.
a specific mention in a particular act, suppose PCPNDT, it is mentioned that it is 2 years. In MTP Act, it is mentioned that it is 5 years. Now, in Income Tax Act, previously it was 6 years from the assessment year, but now it has been amended to 3 years only. In Birth and Death Registration Act, it is 21 years. In Surrogacy Act, it is 25 years. In ART Act, it is 10 years, and after that, you are supposed to submit it to a National Registry. So basically, Madam was right only. As in consumer law, there is provision that you should keep document for 2 years, because patient is allowed to file a case up to 2 years, within 2 years. But the word used there is 2 years from the cause of action. Now, cause of action means there is a rule of discovery which will apply. So suppose you have done tubal ligation operation today and it fails after 6 years. So that 2 years will start after 6 years. So there are examples available where consumers are allowed even to file the case even after 13 years. In the cases of Delhi, only in case of Dr. Soni Verma and this Apollo Hospital case, in which 1 crore rupees compensation was granted, that was allowed after 13 years. So basically, there is no end, case can be filed, and document is for your defense. You have defense if your documents are with you. So if you will destroy your documents, then before destroying the document, you have to give a general public information or public notice in 2 newspapers, one in English and one in vernacular language, that we are destroying our document. If anybody wants any case paper, please collect from our hospital. Otherwise, we cannot be held responsible.
And you
So-
should have a documented protocol for your hospital.
Yes.
That is also very prudent.
Yes. See, delivery file, there is nothing like delivery file. Delivery file is a normal file, and you have to preserve it. Yeah, so you can preserve it for any number of time. If you want your defense, then you can. You have to,
Digital you can, there is no end.
See, nowadays there are agencies available who
Ten
scans your document and put it in cloud permanently. Law never says anything that you should, see, there are guidelines under MCI, that is Indian Medical Council Code of Etiquette, Ethics and Conduct Regulation 2002. It says that you should keep minimum 3 years. Previously it was 3 years for indoor case only. But now in under new NMC rule, they have added OPD and IPD both. So indoor OPD, all case paper are to be preserved for 3 years. Now they don't say that after 3 years you should destroy. They say that minimum 3 years you should keep. Foxy guidelines says you should keep minimum 5 years. So there are individual guidelines. But from our side, it is said that if you want to defend yourself, you should keep for unlimited time. And if you want to destroy, then give the opportunity to the patient to collect their documents, so that in future, if court will demand document from you, you can say that it is to be supplied by the patient only. we are not responsible.
Hospital should have a very clear policy, means you have to keep for that minimum period. There is a, a particular committee you should have in your hospitals, which will do the work of, reading of the documents.
Now, I will take 2-3 questions very fast. Suppose 2 brothers are there. Her mother is admitted in your hospital. One brother says, operation kar do. Second brother says, nahi, operation nahi karna hai. What you will do? ये सब इधर नहीं लिखा है.
Mother's consent. Mother का consent का है.
नहीं, मदर कहती है मुझे कोई अनपढ़ हूँ, मुझे नहीं समझ आती है, आप बेटों से पूछ लो.
According to rule, patient consent has to be taken.
नहीं, mother is 90 years old and she is not with sane mind. Now there are 2 boys sitting outside. One boy says operation कर दो and one boy says नहीं operation नहीं करना है, otherwise I will sue you. 90 years age है, वो समझती नहीं है. दोनों मेजर हैं, 50 years के हैं.
चलिए कमरे में बंद कर दो, लड़ मरा के बाहर.
अरे चलो छोड़ दो आप, 1 मिनट. पेशेंट अनकॉन्शियस है, चलो पेशेंट अनकॉन्शियस है, 2 बच्चे बाहर बैठे हैं, और दोनों मेजर हैं. एक कह रहा है कि मैं कह रहा हूं कि आप मेरी मदर पे ऑपरेशन कर दीजिए. दूसरा कह रहा है कि नहीं, मेरे को बिल्कुल टच मत करना, अदरवाइज आई विल sue you.
In which care, in whose care the mother is?
दोनों की केयर में संयुक्त परिवार है.
Then one has to go to the court and in order to take permission.
So, ठीक, एक सेकंड.
Life saving है तो आप कर सकते हो. Life
मैडम
saving
कह रही है मैं नहीं करूंगी, मैडम कह रही है मैं कोर्ट में जाऊंगी. एनी थर्ड ओपिनियन?
मैं ये कह रही हूँ, लाइफ सेविंग होगा तो कर सकते हैं.
लाइफ सेविंग नहीं है, लाइफ सेविंग नहीं है.
90 years में
लाइफ सेविंग होता तो कंसेंट की जरूरत ही नहीं थी किसी की.
नहीं है, इमरजेंसी.
Very good, very good. So basically the message is you can follow anyone instruction in such case. ठीक है? Document the instruction. एक की किसी के भी नाम की 2 में से एक जो आपको सही लग रही है वो आप कंसेंट ले लीजिए और आप कर दीजिए. एक डॉक्टर अगर कह रहा है कि कर दो ऑपरेशन तो आप उसकी साइन लेके कर भी सकते हो. अगर जो कह रहा है नहीं करो तो उसकी साइन लेके आप रिफ्यूज भी कर सकते
डॉक्टर गीतेंद्र, बट द सिचुएशन इज जिसने बोला कि कर दो, आपने उसका ले लिया, आपने कर दिया और वो माँ मर गई, तो वो जो
कोई बात
दूसरा
नहीं.
है वो कहता है कि मैंने
नहीं,
तो कहा था.
उसकी कोई वैलिडिटी नहीं है. आपके पास कंसेंट है ना एक की कि भाई कर दो, दैट्स ऑल. सो कहने का मतलब यही है कि आपको कोई भी एक फॉलो कर सकते हो. सो बेसिकली व्हेन 2 schools of thoughts are available in law, you can follow anyone. Same principle will apply here. Last is language of consent. ये हमेशा सबके दिमाग में होता है. NABH वाले कहते हैं कि लोकल लैंग्वेज होनी चाहिए, है
It
ना?
should be in patient's language only.
हाँ, तो एक पेशेंट्स लैंग्वेज. कई लोग कहते हैं हैंड रिटन होना चाहिए पेशेंट का. कोई है ऐसा बोलने वाला इसमें? Ideally hand written. Okay, so one is hand written, one is in patient's language. Any other?
हमारे कोर्ट में जाके उल्टा भी बोलते हैं कि मेरे से जबरदस्ती लिखवा लिया था, ऐसा भी हुआ.
So basically ये क्वेश्चन इसलिए रखा है, पूछ रहा हूं मैं, कि कंसेंट इज ए कॉन्ट्रैक्ट एंड कॉन्ट्रैक्ट हैज नो लैंग्वेज. आप अमेरिकन भाषा में लिखा है या फ्रेंच में लिखा है और अगर आप साइन कर रहे हो, इफ यू आर अबाउट द 18 years एज विथ सेन माइंड एंड इफ यू आर साइनिंग समवेयर, it will be presumed by court of law that you have understood and signed. You cannot refuse later on. नहीं तो हर आदमी बैंक से लोन ले लेगा करोड़ रुपए की और फिर नहीं लौटाएगा पैसे, कह देगा मैं तो समझा नहीं था कहाँ साइन ली है, मुझे तो ऐसा मुझे दान दे रहे हैं करोड़ रुपए. तो ऐसा नहीं होता है. So whenever any sane person, even if you are signing on a blank paper, court will presume that you understand the meaning of signing on, or you know the consequences of signing on blank paper and you have signed, unless you can prove in the court of law that this consent was obtained by either fraud or without my it is not a free consent, it was applied, pressure was applied on me, or through some influence they took the consent. So or by fraud it is obtained, or by misrepresentation it is obtained.
But
so
witness will always be there, no, in the consent.
yeah,
Witness
so that's why it is not easy to prove in the court of law that this consent was not obtained properly. because it was taken in the presence of two witnesses. So, Madam has rightly said that every consent should bear last line. That everything which is written in this consent paper is explained to me by this person in this language. And if you write this, and that person who is interpreting should sign as a witness. So that will be the best thing you can do. There is nothing like bilingual consent. NABH is asking that is wrong thing. Even JCI is asking that is wrong thing.
One witness is sufficient or two?
Two witnesses.
One from the doctor side, one from the patient side.
Chalo.
But under PCP and DT Act, that say every state has their forms in their language. There is a column over there.
मैडम इसका मतलब ये है, see I am consultant to more than 200 corporate hospitals and out of them 100 are NABH. So if you want NABH accreditation, they will demand के bilingual लाओ. तो वो लाते हैं बेचारे, बनाते हैं उसको ट्रांसलेट करा करा के कंसेंट बनाते हैं. But it is not mandatory.
गवर्नमेंट ऑफ इंडिया में all forms are bilingual, English and Hindi.
मैडम मुझे आप गवर्नमेंट ऑफ इंडिया का कोई भी लॉ या कोई भी गाइडलाइन बता दो कि कंसेंट बायलिंगुअल होनी चाहिए.
ये नहीं पता मुझे.
फिर
सारे फॉर्म इंग्लिश हिंदी दोनों. सब जगह वही होगा.
मैं बताया NABH में और JCI की रिक्वायरमेंट है, लॉ में कहीं रिक्वायर्ड नहीं है. वी हैड ए कॉन्फ्रेंस विद जस्टिस MS शाह हु वाज प्रेसिडेंट ऑफ नेशनल कमीशन. उनको भी हमने यही कहा था. मैं कहा सर आप एक लॉ बताओ. उन्होंने भी जाके खड़े होकर स्टेज पे एक बार लेक्चर ले रहे थे कंसेंट पे. उन्होंने कहा कि इट शुड बी इन द लैंग्वेज विच पेशेंट अंडरस्टैंड, बिकॉज अंडरस्टैंडिंग इज वन ऑफ द पॉइंट इन कंसेंट, एंड आफ्टर अंडरस्टैंडिंग ओनली पेशेंट कैन गिव यू वॉलेंटरी कंसेंट. सो अंडरस्टैंडिंग इज डिफरेंट थिंग. सी आप मुझे बताओ कितने इंश्योरेंस के कागज आप समझते हो उस लैंग्वेज में होते हैं. अनपढ़ अगर मान लो आप इंग्लिश में भी लेते हो, हिंदी में भी लेते हो, पेशेंट अनपढ़ है, क्या करोगे आप इंडिया की 30 लैंग्वेज है, 30 लैंग्वेज में आप छपवा लोगे फॉर्म. जर्मन पेशेंट आएगा, फ्रेंच आएगा, क्या करोगे. सो बेसिकली देर इज नो लैंग्वेज ऑफ एनी कॉन्ट्रैक्ट. सो कंसेंट हैज नो लैंग्वेज, इट कैन बी इन एनी लैंग्वेज. कैन ए सर्जन डू LSCS? मुझे कंट्रोवर्सीज चाहिए. एक नो आ गया.
नहीं नहीं, इन इमरजेंसी ओनली दे कैन डू, अदरवाइज ऑब्स्टेट्रिशियन एंड गायनेकोलॉजिस्ट शुड बी डूइंग ए सिजेरियन. In case of emergency, if no obstetrician is available, then only.
और hysterectomy?
Hysterectomy, ideally, gynecologist only should be
नहीं,
doing.
हम तो आइडियली बात नहीं कर रहे, हम लीगली बात कर रहे हैं सब यहाँ पे.
No, I think they should not be doing, but practically they.
इंडिया में आज तक एक भी केस मुझे दिखाओ कि सर्जन ने हिस्टेरेक्टमी की और उसको सजा हुई हो.
But they should not be doing.
Should not.
They should not be allowed to doing. They should be persecuted.
So surgeon can take 15 days training and do hysterectomies and LSCS. LSCS, okay. LSCS तो सरकार MBBS को भी अलाउ कर रही है 6 महीने की ट्रेनिंग देके. हाँ. So basically the picture is blurred. No such case file or case record or judgments are available. एक बार अगर कोई केस करेगा किसी सर्जन पे, उसका जजमेंट आएगा तो ये चीज क्लियर होगी. बाय लॉ एक ऐसा, या see there are multiple judgments. In certain judgment it is allowed, it is said that it is allowed, and in certain judgment it is said it is not allowed. See क्रॉस पे थी, आप प्रशांत धनानका का जजमेंट देखोगे तो उसमें लिखा है कि एक सर्जन ने ऑपरेशन किया, यहाँ पे सिस्ट थी उसके लिए, एंड व्हेन ही स्टार्टेड ऑपरेटिंग he found that extension of this cyst is in spinal cord. So at that time neurosurgeon was not called, and ultimately the young chap, electronics engineer Mr. Prashant Dhananka, developed paraplegia. It was a case of 1999 and he got compensation of 2 crore rupees in 2009, and the day on which he got the compensation he died. After 10 years of fight. Sir, वही मैं पूछ रहा हूँ. See, these questions are put only because I want your opinion. These are not the questions which has legal answers. So with due regard, I answer your question that if it is an emergency to save the life of the patient, gynecologist can do appendicectomy. अगर आपने पेशेंट का पेट खोला क्वेरी एक्टोपिक करके और आपको पता लगा ये तो रप्चर्ड अपेंडिक्स है अथवा अपेंडिसाइटिस है, सीवियरली इन्फ्लेम्ड है, you can definitely do the
But
operation.
why not call the surgeon? Because suppose if leak occurs later on, then the gynecologist will be caught.
So if in emergency surgeon is available, it is always advisable to call for. But if not available, then you can definitely आप पेट खोल के तो खड़े नहीं रह सकते हो. So same thing जैसे हाँ सिजेरियन में ब्लैडर इंजरी हुई या हिस्टेक्टमी में ब्लैडर इंजरी हुई तो गायनेकोलॉजिस्ट कैन रिपेयर. Yes.
Just one small thing, it's suddenly remembered when you mentioned this. When you mentioned that nobody has been prosecuted and nobody has, we had an incident where a gynecologist, obviously very competent in his field, he has given anesthesia to his relative and then operated on that patient. Nothing happened to the patient recovered, but you know he was prosecuted in the sense that he was actually censured for it. This was in the armed forces.
So
So
basically
there was
क्या
no
होता है?
legal thing, but he was censured for it. in
Yes,
a
I will
very-
give you example. In one of the cases in Ahmedabad, a doctor gave the treatment to a patient. Cesarean किया, बस खत्म कर रहे, हमारा हो गया पूरा, है ना? तो डॉक्टर ने ट्रीटमेंट पेशेंट को की, पेशेंट पोस्ट ऑफ सीजेरियन डेवलप रिनल फेल्यूर. अब रिनल फेल्यूर हुआ तो जो डॉक्टर ऑब्स्टेटिशियन था, ही हैड वर्कड इन ए किडनी हॉस्पिटल. विनीत मिश्रा के यहाँ पे उन्होंने 5 साल ट्रेनिंग ली थी जहाँ किडनी से रिलेटेड सारे पेशेंट आते हैं. एंड ही स्टार्टेड ट्रीटिंग दैट पेशेंट ऑन इट्स ओन. Although he was not a nephrologist, he was gynecologist, but he had experience to work for 5 years in kidney hospital. So he gave the treatment of renal failure. Ultimately 3 दिन ट्रीटमेंट देने के बाद में पेशेंट did not come out, so he referred that patient to kidney hospital and ultimately patient died of multiple organ failures. Now in that case, when case was filed against doctor, it was said by the court that although you may have experience, but in Ahmedabad there are more than 17 nephrologists available. For continuous 3 days, why didn't you bother to take opinion of one nephrologist at least? So basically, whenever any specialist services are available, it is always advisable to take the services. But if it is not available in emergency, you can definitely do the surgery which is necessary for the. Last question, if you are a postgraduate doctor, you are registered in Delhi Medical Council. Now you have registered your MBBS degree and you have forgotten to register yourself or upgrade your degree in Delhi Medical Council as an MD or MS. You have done, okay. Can you practice as a gynecologist or not? How many knows how many yes? आपके पास डिग्री है MD की MS की, आपने कोर्स पूरा किया है, सिर्फ आपका रजिस्ट्रेशन DMC में नहीं हुआ है, आप कर सकते हो कि नहीं कर सकते हो?
Degree is recognized, then
नहीं, रिकॉग्नाइज्ड है, सब कुछ रिकॉग्नाइज्ड है. आपकी MS की डिग्री है और अच्छे हॉस्पिटल से है, रिकॉग्नाइज्ड डिग्री है, खाली आपने रजिस्ट्रेशन नहीं किया DMC में, भूल गए.
दोबारा से अप्लाई कर दो सर और अप्लाई
Catch 22 happens, ma'am. We get so many senior residents who are coming from other states. They are having valid MD or MS degrees. Now they apply. Even DMC takes time. At least 1.5 months they take. They will check the
एप्लीकेशन
document.
अगर आपने कर दी है ना तो
She has applied, but we employ them
मैं तो
and
बोल
they
रहा हूँ
are working.
आपने अप्लाई नहीं किया, खाली ऑन पेपर आप DMC
They
में
have received
MBBS हो.
second work. तो नहीं कर सकते. अप्लाई नहीं किया तो नहीं.
सो बेसिकली टू अंडरस्टैंड, ये क्वेश्चन इसलिए रखा गया है कि एक क्वेश्चन ऐसा आया था हमारे पास जिसमें एक डॉक्टर MD को रजिस्टर करना भूल गया और एज एन MBBS की डिग्री पे वो DMC गुजरात मेडिकल काउंसिल में प्रैक्टिस कर रहा था. नाउ ए केस वॉज फाइल्ड अगेंस्ट दैट डॉक्टर इन द कंज्यूमर कोर्ट. तो हमने कंज्यूमर कोर्ट को प्रूव किया कि he is qualified enough, he can practice. Now action can be taken by state medical council for doing unethical act, but you cannot be said that you cannot practice at all. आप प्रैक्टिस क्वालिफाइड हो, एक्सपीरियंसड हो, आप प्रैक्टिस कर रहे हो तो यू कैनॉट बी हेल्ड लायबल इन कंज्यूमर लॉ और सिविल लॉस फॉर द सेम, बट यू कैन बी हेल्ड लायबल अंडर स्टेट मेडिकल काउंसिल फॉर डूइंग अनएथिकल एक्ट. ओके, सो ये मैसेज इसलिए दे रहा हूं कि कभी किसी के साथ ऐसा हो जाए, सो वी आर देयर टू प्रोटेक्ट
सर
यू.
एक
There's another last topic.
Thank you very much for giving us the opportunity.